don't want to mix up the paperwork with you.
No, please, take some time.
I did. Yeah, it was
Still got 2 minutes, yeah.
in the back room.
1 minute.
Oh, that's my hair.
I think we're ready.
Got 1 more minute. That's all it says time. It's 5:59.
Is she ready? She's ready?
In a minute.
Oh, yeah.
1 minute.
And then do we need mics?
Nope, IT said it'll pick up, you guys just fine, what it is.
I guess it was just in the big building.
And sometimes they've had it in here, but
We better look at this in case someone says it can't.
smaller.
You ready?
Just check your deal was running.
Huh?
It's gonna be again.
Yes.
Yeah, it was short.
Ready, Wanda?
Sort of, yeah.
So, yeah, is that a yes, no?
Sure. Yeah, I'm good. Go ahead.
You good? Everything's on?
Yeah,
We're good?
yep.
Okay, we'll call the meeting to order. Notice is posted in accordance with Wisconsin statute 19.84, open meeting law. We have proof of that?
Yes. Ooh, right there. It's in there.
Okay, thank you. We got the secretary read the notice of public hearing.
Notice of public hearing, State of Wisconsin, County of Burnett, Monday, December 6, 2021, at 6 p.m. at the Burnett County Government Center in room 165, Town of Meehan, Siren, Wisconsin, regarding the following. Appeal 2101, Chelmo. Notice is hereby given to all persons in the Town of Meehan, Burnett County, Wisconsin, that Daniel Chelmo has made an application to appeal the decision made by the Land Use and Information Committee in reference to the conditional use permit CUP number 2109, located at 27060 State Road 35 in the A2 zoning district in the southeast quarter of the northwest quarter of the southwest quarter of the northwest quarter, section 4, 3916. 2, variance number 2126, Francis. Public notice is hereby given to all persons in the town of Jackson, Burnett County, Wisconsin, that Tom Francis has made an application relative to a proposal to vary the terms of the Burnett County Land Use and Shoreland Protection Code of Ordinances as follows. To construct 98 square feet of deck within the lake setback area of Sand Lake, Lot 1, CSM, Volume 6, page 259, located at 27553 Thompson Bay Road in the RR1 zoning district in Government Lot 2, Section 364015.
Okay, thank you. And then we have a motion for approval of agenda order.
I approve the agenda order.
Second that.
All in favor, signify by saying aye.
Aye.
Carried. Okay, meetings procedures. The board members have visited the sites. Public comments will have a 3-minute time limit. Hearing is being recorded, so we ask that only one person speak at a time, so that otherwise if we overtalk each other, they can't pick that up in the recordings. Board asks that one person from the announced variance or appeal be designated by the applicant to present their case before the board. They come up and sit here or online. The board will then ask for public comments and any received correspondence from local authorities or neighbors concerning announced variance or appeal. Then the board will close that portion of the hearing. Once we've heard from everybody and listened to everything, then we will close that portion of the hearing and then we'll deliberate amongst ourselves. And then we may ask questions if we have questions, but that portion is closed, and then we will vote and you'll know what the outcome is yet tonight. Applicant, local officials, and DNR shall receive within 30 days a letter summarizing the hearing, also including information on applicant's rights to appeal the decision in circuit court within 30 days. Any person aggrieved by this decision or taxpayer or any officer, department, board of review, or bureau of the county may within 30 days after filing of this decision in the office of the Board of Adjustment commence an action in the circuit court seeking remedy available by certiorari. So with that, we'll start with the,
We have one person signed up for public comments.
okay,
Need to ask them, though, they're also signed up underneath the items. So we want to see if they're going to speak now or
okay,
later.
so you're checking on that?
Yep, we're gonna.
Okay, we'll just give them a second here. We're gonna start the public hearing, appeal APP 2101, the Chelmo appeal, the decision made by the Land Use and Information Committee in reference to a conditional use permit CUP 21-09. It's located at 27060 State Road 35.
Hold on, Dennis.
Yep.
We gotta ask. So Joe, you signed up to speak during public comments and on the appeal. Do you want to speak 3 minutes now? Or during the hearing?
Well, I'm sorry, can you hear me?
Yes.
Yeah, I was going to make a general comment now about the process, and then I was going to make a substantive comment at the agenda item, but I can, if I have to choose one, I'll choose the agenda item.
You can do both. That's fine.
Well, the
Okay.
public comments are for anything different than the appeal or variances that we're listening to tonight. That's what the original public.
What?
So if you're gonna speak towards the one of the appeal or the variance, then we would wait until we're doing that specific one.
All right, then I'll just wait, because even though it's general, it'll seem like I'm trying to get 2 bites of the apple, so I'll just wait.
Appreciate it. Okay. So how we got here with this appeal is that we had an appeal for this hearing, and we heard this back 3-4 months ago, whatever it was. And then we found out that it hadn't been published correctly in the paper. So then we had to redo the appeal. So they redid the appeal a month ago or so, and in doing that, once the board was deliberating, they decided they needed clarification on what the decisions were of why the committee made their choices to deny the appeal. And so they sent it back to the committee to give them that information, and then now that's why we're here tonight, to continue on with this. So the CUP 21-09 clarification is discussed on 11/2/21 of the committee on this, is input from the town of Meenan and village of Webster, both in operations representing their citizens adjacent to and in their jurisdiction. That was one of their issues. Hours of testimony and volume of written and email comments almost entirely in opposition. Unsafe access, lack of approved access, no DOT or county approved access makes application incomplete. DOT would require turn lanes in both directions and the responsibility of the applicant to pay for them. Public health, welfare, and safety, the septics and soil conditions, no specific system design plans were submitted. Road access, none approved. Effect on neighboring properties. The character and density, radical change from agricultural field, woodland to high-density camp. Purpose and intent of the zoning district, Meenan lacks comprehensive plan. And then a note that the campground work group meetings started after this public hearing for the CUP 21-09 took place. So the original application for this was before the campground work group meetings. So that's what they submitted back now for the Board of Adjustment to review. And now we're going to take testimony, and we will have Lee, the attorney for Chelmo, start. And then there's another attorney, Joe, for the Devil's Lake Association, I think, or whoever he's representing. And then we will hear the people that are online that want to speak in. Once we're through with that, then we're going to take testimony from anybody here that wants to give their testimony. And then we'll go from there. And then from that, we will close that portion of the hearing, and then we will deliberate amongst ourselves, and we'll hear the determination yet tonight. So I think that's a summary of where we are, and so we can start. If Lee is ready, we could start.
Hello, I'm here.
Yes, Lee, we can hear you.
Okay, thank you. Am I timed on this?
No, you are not.
Okay. Okay, well, I'll just pick up, I guess, where we left off then. We've all been here before, twice. And just go right to the new part, which is clarifications. The appeal is based on several different specific legal arguments or questions, which I think are not sufficiently answered by the facts or are just not supported in the law whatsoever. And that's what the appeal was based on. And those are difficult things to answer when maybe the facts aren't apparent and you don't have your own legal advice, which the Board of Adjustment was not given independent advice. And my interpretation or my impression was when it was sent back is maybe some clarification on the statements, but also some clarification on the facts that applied to different things. I did observe the Luke meeting where they went over these clarifications, and they just chose not to make any additional factual findings at that time. One of the Luke members stated it was because they kind of just take it all in when they have a hearing and they don't specifically pick and choose the basis for the different things they decide. That's kind of the problem here. We do need some specific bases for some of these things in order for them to make sense, and the lack of that is why the legal arguments were made that they weren't sufficiently done. That's the whole point of the appeal. So I've reviewed the clarifications. I wrote in a letter about them. Essentially, I don't see how they really even changed anything. Nonetheless, I go through each of those in turn. A couple general things, though, that need to be stated here. And I think the Board of Adjustment's direction maybe on this first one is apparent. You know, there's people arguing about whether you consider the record or consider things outside of the record, and it's just got to be one or the other. Most people arguing about the record are with the other hand trying to submit something else, and it's got to be all or nothing across the board. I just want to make that point of fairness. At the original Luke meeting where this occurred, it just needs to be stated that I would not assume that all evidence was taken. The format was, we have an application, we were given, I think, 3 minutes. They heard all the public comment in opposition. We were not allowed to speak again. And then decisions were made based on those public comments, which were not verified in any sort of way. And that's why I'm making the point about findings of facts to underlie these legal arguments. Not all evidence was taken. We weren't allowed to give any. Once the application was discussed, that was it, and we weren't allowed to respond to anything. And that's part of the arguments we make in our original appeal, and also I think the same original arguments still stand. Just to go through those briefly. They added certain clarifications like input from the town of Meaning and Village of Webster, that they represent their citizens and they're adjacent to and in their jurisdiction. I mean, we submitted specific information that these don't really seem like ironclad opinions of the municipalities themselves, but people that have, you know, agendas to chase and use those bodies to do it. And first and foremost, though, even beyond that, there's no legal mechanism whatsoever. Someone can send an opinion, but the point is, what is the content and the merit of that can be investigated for its actual effect. And to say that a municipality with no legal authority whatsoever stated an opinion doesn't really have any legal effect. And nothing's changed there. And I don't even understand what they mean by speaking for people adjacent to their jurisdiction. And anyone who's done any service knows that even when you're within your jurisdiction, no matter what you say, someone's going to be against it. There's never 100% type of comment that's made on behalf of the public. People do the best they can. But this idea that there's somehow 100% this or that opinion just because someone got a letter in from a municipality that has no legal effect on the question, that really shouldn't mean anything. The second point that was, frankly, I was dismayed to see. They're just looking at the volume of these opposition comments and not really their content. And again, it's the value of them is to investigate the merit to see if there's a legitimate reason. And that reason would be adopted as a finding. We find that this comment, this is, we looked into it and now we find this fact, and based on this fact, we come to this conclusion. None of that's done. It's just taken for granted. Whether it's for or against is what they wrote here. It's the content that's supposed to have some import. And we know for a fact, and we've stated in our submittals, that these are like internet form letters where people are recruited to customize their form letter and send it in. These are not, independently arrived at opinions, and it's just buzzwords and getting someone on the internet to sign a line, and that's really unfortunate. We have not been doing the same. I'm sure there's some people that would be supporters of the campground somewhere, but we haven't been trying to generate random letters on the internet as proof. We've just been trying to follow the law and have hearings that are fair. The third one, this road one, unsafe access, lack of approved access. There is, in fact, an access right now. That's factually wrong. The applicant has been in touch with the relevant authorities about different types of accesses that are possible. He's received information about what would be possible to have a safe access. It's stated here that the applicant would have to pay for them. We know. We know that. So how is this a reason to deny? It maybe would be a reason for a condition on a permit, but there were no conditions offered on the permit. This was unilaterally stated without giving the applicant a chance to respond as a reason to deny the permit. Now, that doesn't make any sense. Were they afraid that he would agree to it? When you're not even provided the opportunity to agree to a condition, how can it be a reason for a denial? That makes no legal sense or other sense to me. The next one, public health, welfare, and safety. Again, there's no requirement anywhere to have a full septic layout supplied with the initial application. Just as there's no requirement anywhere to have the full road access prior agreed before you submit the first application. Those are things that are secured in order to carry out the use once you know you have the ability to try and do it. I think people are generally aware of that. Effect on neighboring properties. Which effects? That's the findings we don't have. Is there a defined, arrived at effect that causes, that we know, by the way, speculatively, in advance for certain, that's going to cause some sort of bad effect, and based on that, we can make this decision? We haven't even gone that far because we're not even naming the effect. Everyone's use of property has an effect. Everyone's use of their property. The point is whether it rises to a level of an illegal effect or not, or something that would rise to a level to make a decision. But to review that decision, it has to state what it is. And again, stating effect on neighboring properties doesn't actually provide us with any more detail. The next one, character density. It's allowed. It was applied for because it's allowed in the zoning. Generally, when something is allowed in the zoning district and it's available for application, the answer wouldn't be that the zoning district doesn't allow it. That's just an internally inconsistent argument. It doesn't really exist. When you don't want to allow it, you take it out of the zoning district. In the ongoing amendments to some of these ordinances, you've seen that going on, and that's an appropriate way to deal with an issue. But Luke is not a legislative body. They just can't make a determination that we're just not going to follow the ordinances. They may not be worded the way you like, just like any other law, but then you wait for that process to change them, which the county's had ongoing, as they should if they want to change them. But it's not Luke's job to just change it in advance. There's nothing in that ordinance that says you can't have a campground where there was a woodland or an ag field. There's nothing in that ordinance that defines what, quote, high density, end quote, is. These are made up words. They're not based on an ordinance definition. And again, these are made up words from public comment that have no basis anywhere. And they become a reason to cite for a denial of a permit. And again, there's no back and forth. There was no discussion with the applicant. Well, what about this layout, that layout? I mean, there was no discussion at all. Purpose and intent of the zoning district, I think I covered that already. If it's allowed in the zoning district, that's how you know it's allowable. A conditional use, yes, is something that you want to treat with some more review because it may not be appropriate without a lot of conditions. Maybe something would have so many conditions and the applicant doesn't want to do it. But we never even got to that stage. We just had an application, public comment, and a denial without any back and forth about what possible conditions might have been. And the note about the campground work group meetings, I'm not sure entirely what that's supposed to mean. I did submit some of those comments, I believe, in some of my writings, because it did quote a lot of county officials as to general items, as to whether it's generally safe or generally acceptable or what general law enforcement responses have been. And we don't need to get down that rabbit hole if the BOA thinks that's something that shouldn't be considered. But I put it in there because it's the local truth of the matter. I mean, people have looked into it. We know what it actually is. And to the extent we have hearsay comments that say the opposite, you know, there's a reason to re-examine those or not to take those for granted. I think that's what's required when I talk about hearsay comments as opposed to evidence. And I think that really makes that clear. So I've tried to add more detail just based on the clarifications as received, but I haven't really changed any of my original arguments. We were looking for more information. I missed one thing, this comment by Luke about an incomplete application. Incomplete applications don't get heard by Luke. They're sent back to the person to get them complete if they want to proceed. If they don't have enough detail that they want, it's right in the ordinance that they can require more information. And we've been down that road before. No more information was asked in this matter. Things were simply denied outright without any discussion or any request for more information if any was required. We could have provided more information, but we weren't given that chance. And that's really the sum total why the appeal is here today. You know, we believe it's legal. Some other people may disagree. We think a permit should be issued. Some people may disagree. But at the end of the day, you got to have a fair up and down examination and vote. And that's where people can move on both sides if that's what they need to do. But this stuff where we don't have facts decided, it goes back. We still don't have facts decided. For whatever reason, even though the bylaws require it, the bodies aren't being given legal advice as to these arguments that are being made. You know, that's some internal review, I think, issues, but I don't see why the applicant should have to suffer for that unnecessarily. He complied with the law, submitted the application. it was complete or he went ahead a hearing, although I question whether he really had a substantive hearing if he wasn't allowed to address any concerns that came up or discuss possible conditions. It was basically rejected out of hand, and we find that unfair. And again, that's why the appeal was generated. Those would be my overview comments.
Okay, thank you. Who do we have next on the line there to listen to? So, Joe, is Joe there?
Yep. On a second, just
Sorry, hello?
Joe, is that you?
Yes, can you hear me?
Yes.
All right, very good. Should I proceed, and am I under the tight 3-minute limit, or
Yeah,
can I get a little more time?
Everybody on out now is 3-minute limit.
Yeah. All right. Should I go ahead?
Yes, please.
Okay, thank you. Again, Joe Sincata, I'm an attorney for concerned citizens of Devil's Lake. Property owners near Devil's Lake, as everyone knows, are also near the Yellow River, which is this cup that the LUIC denied. The comment I want to make, that I was going to make earlier, but is applicable today, but is more generally also applicable, is that the LUIC and this body and other bodies at local levels should hear and consider public comment. The common theme of the appellant's argument is basically don't listen to the public, and then we try to minimize and undermine their statements. Act 67, you're probably familiar, which deals with conditional use permits and the process for reviewing and granting or denying them, does not in any way prevent public statements and comment and the facts from those statements being considered by, for instance, the LUIC and this body or other bodies. In fact, the appellant's attorney, Mr. Troney, and I were just both involved in a recent court case that was heard by Judge Winton in Washburn County, but it was she was sitting on behalf of Burnett County. And this general issue was brought up by Attorney Troney forcefully, and to his credit, he articulates this point. But I disagreed, and the judge disagreed. The comment that was provided to the LUIC on the earlier cup and on this cup is perfectly appropriate. I mean, that's deliberative democracy. It's not prevented by Act 67, and it wasn't hearsay. That's a misnomer that there's hearsay going on here. So Act 67 specifically allows for and encourages these types of comments. So do the county ordinances, which is why the LUIC made the substantive decision on the merits, and why I think this body is really set up to review whether they did a reasonable job. Let me try now to respond quickly to a couple of comments made by Mr. Troney. I wish I would get a chance to re-respond. I mean, I know he gets to. I say that because his main theme is that things are not been fair, but they really have been fair. They've been more than fair for him and his client. He has the opportunity to provide an application that fully satisfies the ordinance. That's what Act 67 requires. The applicant has the burden to demonstrate that it satisfies the requirements of the ordinance. If there are fuzzy words in that ordinance, the LUIC is the body that determines what that means and then considers the facts presented and determines if it meets the ordinance. If appellant doesn't like the fuzzy language in an ordinance, it has to seek to change the ordinance, or it can make a grandiose constitutional argument that somehow it's vague. This isn't vague. The LUIC did a good job, and they properly denied the permit. So there was plenty of fairness. In fact, I wish I had more time because I'm going to run out here and be able to respond to all these comments. So was that sound, my time?
Yeah.
Okay. Well, thank you.
Yeah, thank you. Are you going down the line?
Yep, now you'll go down the list. Greg Whittaker, 939.
Oh, we-
Was it on site though? You want to do remote? Want to do all the remote?
We'll do all the remote first.
The on-site people.
We can.
There. All right, so Greg Whittaker should be able to hear us.
Greg Whittaker?
I can hear you. Can you hear me?
Yep. So you can begin.
Oh, great. I just wanted to affirm that the LUIC adhered to Burnett County Chapter 30, Article 8. You know, they were supposed to hear all the evidence, weigh the evidence, and after doing so, they determined that CUP 2109 is incompatible with A2 zoning. CUP 2109 would have a negative impact on important criteria like health, welfare, safety of the county and immediate area. You know, Mr. Chelmo's legal said that this is an allowable conditional use. That's correct, but that's why we have the conditional use permit procedure to weigh the evidence and make a decision that is based on evidence and fact, which is exactly what they did. And after hearing the evidence, they determined that this conditional use, although may be allowable after review, is not appropriate and should not be approved. And so again, as Joe said, Act 67 encourages public comment, and then we take the facts from those comments and we make an appropriate decision, which is exactly what the LUIC did. And, you know, finally, I would just say, once the decision is made, now it is up to you to determine whether there was any error or abuse or injustice, and there were none. It was perfectly fair, as Joe also commented. And after hearing all evidence, the evidence shows that this denial was absolutely appropriate, and not just opinion and hearsay, but entirely based on legal precedents and fact. And so I would ask you to please affirm the LUIC's decision to deny CUP 2109 and deny App 2101. Thank you for your service. Thank you for your time.
Okay, thank you. Next, Christina Whittaker, okay.
Christina?
Hello,
Christina, can you hear us?
I can hear you.
Yeah, we can hear you. You can begin.
Hi, good evening. Christina Whittaker. I'm a full-time resident on the Yellow River, just south of the proposed campground, and I'm calling today to support the Burnett County Land Use Committee's decision to deny the Chelmo CUP 2109. The April 6, 2021 land use meeting accurately reflected that the proposed CUP conflicted with the Burnett County Comprehensive Land Use Plan and was not compatible with the intended use statement of the A2 zoning district. The denial reflected the evidence-based concerns that the CUP presented and how it would have a negative impact on the health, welfare, and safety of the neighbors, neighboring lands, and waters. The Village of Webster, Townships of Meenan, all opposed CUP 2109, reiterating the concerns of the public and the Land Use Committee's decision. The committee determined the proposed CUP was incompatible of the purpose with A2 zoning, and the applicant failed to meet the necessary categories that a CUP requires. The record is clear, and we're asking again that you affirm the committee's decision again to deny CUP 2109 by denying Chelmo Appeal 2101. The committee carefully weighed and applied the proper protocol with all the evidence presented for this proposed CUP before making a decision. The committee fairly determined that there was substantial evidence to warrant denial due to the unique problems this CUP presents at this particular location. My understanding is that your purpose is to determine whether or not proper protocol was followed with the Land Use Committee's decision with the denial. And the weight of their decision is heavily weighted and it was evidence-based and fair. Please reaffirm tonight that the proper protocol was followed and there were no errors of record. This CUP was properly denied, and the LUIC unanimously voted as such. Thank you so much for your time and consideration this evening.
Okay, thank you. And then next, Patrick Hansen. Okay.
Mm-hmm.
Patrick, are you there?
Yes, I am. Can you hear me?
Yes, we can hear you. You can begin.
Okay, my name is Patrick Hansen. I own property 11465 North Shore Drive in the town of Wood River. First of all, I want to thank the Board of Adjustment for your service to the Burnett County and all the residents and taxpayers here. I have found across the board at the town level and at the county that we are served by some fantastic public servants. And I haven't had many opportunities to speak to this body, but I've spent a lot of time talking to Land Use and Information Committee and others at the county board. And I just have to say we have some fantastic people, and I imagine that's true here as well. So thank you for your service. It's so discouraging to me to hear a lawyer talk about public process and the government as if it were irrelevant and didn't matter, the government being the town of Meenan and the village of Webster. The town of Meenan wrote a very thoughtful letter, a very fact-based letter opposing CUP 21-09. The village of Webster wrote a very thoughtful letter based in fact and law, based on the fact that they have extraterritorial authority over some of this land along the Yellow River because it affects them. And so their letter is not just a matter of opinion, it is a matter of fact and has a legal basis to represent the position of the village of Webster on this particular project and the impact of that project on the village. We also have the Land Use and Information Committee, which, as you heard, and as you know, voted unanimously in opposition of CUP 21-09. They even reconsidered that, clarified, and sent the information back to you all again as they were asked to do. And then we have hundreds of residents and taxpayers who have shared a variety of facts that inform this decision as well. And so what we have is one very smart lawyer saying that the Land Use and Information Committee is wrong. The village of Webster is wrong. The town of Meenan is wrong. Hundreds of residents and taxpayers are wrong. And that poor Mr. Chelmo has somehow been wronged in this process. And that's just not true. Apparently, Attorney Turini doesn't believe that the residents and citizens of Burnett County have the right to petition their government. He dismisses that as just form letters. That is a petition. That is a group of individuals, real people, including myself and others who are speaking to you here tonight, who have taken a common position based in fact, based on the impact to them and to their families in opposition to CUP 21-09 and in support of the Land Use Committee's decision to unanimously deny it. And so I ask that you deny Appeal 21-01, deny this appeal. Let's end the permit ping pong that's been going on here. Let's put the lawyers out of work. Let's let them move on to other things and be done. Thank you so much for your time and for your service.
Thank you. Next.
Should be Cindy, should be on.
Okay. Cindy, can you hear us?
I can hear you. Can you hear me?
Yeah, I can hear you. You can begin.
Wonderful. Thank you. Well, here we are again, reviewing Mr. Chelmo's CUP 2109 denial by the Land Use and Information Committee. I'm still unsure how or why your board returned this CUP to the Land Use Committee at your September 20th meeting. It seems apparent to me that the committee's decision to deny CUP 2109 was thoughtfully considered using the guidelines set forth for granting CUPs in the Burnett County Muni Code Chapter 30. In accordance with Section 30-633, the committee was required to and did consider the impact of CUP 2109. After considering and weighing all the evidence presented, the Land Use and Information Committee correctly determined CUP 2109 was incompatible with the purpose of an A2 zoning district, and it would have a negative impact on the health, welfare, and safety of the county and immediate area. The committee voted unanimously to deny Chelmo's CUP. How can it be alleged that an error, abuse, or injustice occurred when the motion to deny was based on the specific requirements outlined in the zoning ordinance? The Land Use Committee twice correctly determined there was substantial evidence that CUP 2109 failed to meet the zoning threshold for approval, and it was properly denied. I'm asking you tonight to please affirm the Land Use Committee's decision to deny CUP 2109 and deny Appeal 2101. Thank you for your service and your time tonight.
Thank you. And Steve, next.
Just 1 second. Okay, Steve should be there.
Steve, can you hear us?
Yes, this is Steve White. My address is 26943 Riverwoods Trail. Having attended many of the meetings on Mr. Chummo's campground proposals, I believe the Land Use and Information Committee made the correct decision this fall in denying CUP 21-09. A campground with a large number of people along the Yellow River that threatens the safety and welfare of Burnett County residents is the last thing this area needs. For these reasons, I ask that you accept the Land Use and Information Committee's extensively researched decision and finally put an end to this ill-planned campground proposal. Thank you very much.
Thank you.
Should be to in person. Jerry Krause.
Jerry Krause, are you here?
Sam, thank
Yep.
you.
Up here? Yeah, if you want to sit at the chair up here, we can hear you better then.
Thank you, Mr. Chair. Ms. Schmidt. My name is Jerry Krause. My wife and I own a cottage on the Lake Minerva chain at 6720 Hayden Lake Road in Danbury. I'll be brief. Please deny this appeal. As others have already said, the LUIC did its job, finding the CUP 2109 to be incompatible with the purpose of the A2 zoning district and would have a very negative effect on the health, safety, and welfare of the county and the immediate area. I also want to respond to counsel for the applicant. I find really fundamentally disingenuous his attempts to denigrate public comments. As Patrick Hansen said a few moments ago, we are encouraged as citizens to petition government and to sort of turn that on its head and suggest that public comments and concerns, heartfelt concerns about their community are somehow merely just hearsay and totally unworthy of a governmental committee such as the Land Use and Information Committee for their consideration. I find that to be offensive on a whole number of levels. Perhaps it's understandable that the applicant is displeased by the LUIC's decision. However, there's simply no error here. The applicant's quarrel really is with Act 67, the county ordinance, and the requirements, not with the LUIC's decision-making process. Thank you very much, and thank you for your service.
Thank you. Stoffel, Tim Stoffel, you?
My name's Tim Stoffel, and I've got a place on 7154 Devil's Lake Drive. I support the prior decisions made by the Burnett County Land Use Committee to deny Chelmo's conditional use permit 2109 regarding the campgrounds along the Yellow River. I also find it very disheartening that Chelmo's attorney generalized and said everything that the public made was opinion and it's hearsay. That is not the case. The applicant failed to provide any evidence of his own that the CUP 2109 would not negatively impact the health, safety, welfare of the neighbors surrounding this property. Under Act 67, it states that the applicant must demonstrate that the applicant and all requirements and conditions established by the county relating to the conditional use shall be satisfied, both of which must be supported by substantial evidence. And the county's decision to approve or deny the permit must be supported by this evidence. This section of the statute is often left off or out of the correspondence between the applicant as was done in Chalmo's application. He didn't have any of this evidence presented. Sorry about this. A little harder to read when you get old here, when you the cheaters. So those requirements, if those requirements aren't satisfied, as they were not in 2109, the issue of whether specific conditions should be discussed or applied to the project is never even reached. Statements from the adjourning neighbors, property owners, and the public are fully acceptable as substantial evidence when they contain facts that rise from the knowledge of the local conditions. I, in fact, got an appraiser who said what the economic impact would be by putting a campground next door. Mr. Chalmo never did any work to go find his own appraiser to say if the economics would go up or down. So at the original meetings, there is substantial evidence presented by the public, verbal and in writing, that thoroughly discussed 2109, that it demonstrated that it was be negatively impact the health, safety, welfare of the surrounding areas. Public comments are specifically allowed by the Supreme Court's decision in All Energy Corporation back in 2017. This was also reaffirmed just a few months ago by the Burnett County Circuit Court, with respect to a Chalmo appeal on on his 2019 Cup for the Devil's Lake campground. And it was the attorney tried to wrongly say that the public comment is not substantial evidence, when in fact the court rejected that argument and confirmed that public comment can be considered. So I support the Land Use Committee's 2 times decision to deny this cup. Please do so also. Thank you for your time and service tonight.
Thank you. Rose, are you here? How do you say your last name?
Catapano.
Catapano, thank you.
I'm Rose Catapano. I own a cabin at 7154 South Devil's Lake Drive in Webster. I support both decisions made by the Land Use Committee to deny the Yellow River Campground Cup 2109. The Land Use Committee properly considered all the input and facts from the applicant, from the public, and appropriately determined that the cup did not meet the requirements. At the meetings, the taxpayers did demonstrate that Cup 2109 would have a negative impact on the health, safety, welfare of neighbors and their surrounding property. Taxpayers' input does matter. This decision was reaffirmed in the circuit court this past September in a case with the same applicant. The applicant has had numerous opportunities to present his position. Please, as everyone else has stated ahead of me, please reaffirm both the land use decisions by denying Appeal 2101. The Land Use Committee fairly determined there was substantial evidence to disprove Cup 2109 both times the cup was discussed. A proper and appropriate review of the facts was performed and the application was denied. Thank you for your time.
Joy Drosso.
Hi there, Joy Drosso, Burnett County resident. Keep it quick. I was at the April 6, 2021 meeting where his application was denied, and the Land Use and Information Committee did hear many facts, and it helped establish the reason for their denial of the application. Their decision was based on substantial evidence. Substantial evidence was provided by the public, by the Village of Webster, and the Town of Meenan. The record is clear that the Luke followed and properly applied the appropriate ordinances and legal requirements before reaching their decision. And it is all documented on video. You can get every single word from that meeting by going to the Burnett County YouTube channel and watching the entire meeting. I ask that you please affirm the Luke's decision to deny Cup 2109 and deny Appeal 2101. Thank you.
All of them for that one.
Everyone checked off.
I don't know if you want to ask if anybody else in the audience that hasn't spoke would want to speak. Sometimes people forget to sign up.
Everybody spoke on this on the appeal that was gonna? Do you have any questions for anybody? No? So we can close this portion of the hearing, and we can go into deliberation amongst us and go from there. You okay with what you got there? Yep. So, okay. Okay,
Just tell me if you have any questions for the applicant, and I'll review them.
okay, appreciate that. I hear you.
Okay.
And they hear too.
Okay. Lee indicated that Mr. Chelmo has not ever had a chance to address his concerns to us. And I recall being at a meeting previous to last time when I wasn't here, that he had an opportunity to talk, and it seemed as if he spent a lot of his time talking about the road in and the hauling of fill, which caused the disruption of the blacktop. And,
And that was on the other.
okay, that was,
That's not this
I'm sorry,
application.
okay.
Yeah.
So have we had other opportunities where he has spoken, or has he chosen to let his attorney speak for him?
Yeah, no, he's had his chance to speak,
That's
and
fine,
so is the attorney.
okay. So every
At
time,
all of the hearings.
yeah, so every time he's
And on
had
this
a
one, we've
chance.
done, this is the third time now.
Yeah.
So we can listen to new information. I didn't hear anything new tonight from either side that was new,
Okay,
that I haven't heard or read, you know,
No.
all our paperwork, and this isn't even all of it.
Right.
But, they've had opportunity to submit this additional information, because it could have come to us tonight, you know, DOT access and how they're gonna do that, and some of the key information here that we need, and the kind of the DOT access is one of the biggest ones there, that how do you get in there, that it's a crowded area on the highway. Doesn't work very well, you got swamp all the way to the hill, to the corner, and then the hill, you got a corner and a hill that you can't put access into the big rigs. No, that doesn't work, so that really is the biggest one that needs to be resolved, and we still don't know what that is. I think that the input from the town and the village of Webster, and then all the concerned citizens, it has a huge impact. You know, how many letters have we read through and all this stuff like that? There are a lot of issues that need to be addressed, and none of that's done. One thing that I would need, if I were gonna approve this, I would need to know what you do if there's a major storm like we had 10 years ago come through the town of Wyatt. Where do you put the 100 or 200 additional people there? Where do they go? Are they providing storm shelters? No, they're not. None of that's been included in their applications or anything that they're dealing with. Some of these concerned citizens have. And I think the character density is an issue, going from egg and woodland to, you know, high density campground. That is a change. I mean, that's huge. So. I guess I'd make a motion to affirm the committee's decision.
I second it.
Motion and a second. In favor, signify by saying aye.
Aye.
Aye. Carried. That's it. thank everybody's patience.
Thank you.
Appreciate the patience here and working with us. And
Thank you.
if you give us a minute here on the next one, we just need to give us 5 minutes here to get straightened out here and get ready for the next one. If you have somebody waiting online, is that what it is? Are you?
There's one.
One online and one in person.
Okay. I think so. That's what I wanted to say, to make sure. Okay, here goes. Are you okay? Yeah, you okay?
I guess we'll clean out together. See ya.
Okay. Let me get to. You said you want the reserve speaking, you can reach out to them with the financial resources.
Yes.
So you read that. And you get the stamp. So you got that. You got everything. Okay. Are you ready? Ooh, that's really good. Thank you. Is that for me? Maybe it wasn't. I took somebody else's. I'm sorry. I thought you put that there for me.
Wasn't me.
Appreciate it. It's good.
I should have spiked.
I should have.
There you go. Oh, I bet you put.
Yep, poison.
Yeah.
Never know.
Shoot, the attorney put it there.
Yep.
Good, ready?
Mhm.
Yep, I think we're all good, yeah.
Ready?
Yep.
Okay, next one is variance 21-26 Francis. Is there somebody here so if you could come up and start and kind of give us a summary of what you're proposing and, we'll start with.
Okay, my name's Tom Francis. Karen, my wife, is here, with me. My parents have owned the property we're talking about since the early 1960s. They purchased it from my great uncle Glenn Thompson, who homesteaded the property in 1910. I've been participant or fully responsible for maintaining the property since that time. My father had a heart attack at an early age. We've experienced many major weather events that have blown down many trees during the past 55 years. Further tree or building maintenance will require access to lakeside and roadside portion of the property, both the building and for down tree removal. The proposed location of the new home will allow access to both. We're having to move the well, which we put in 7 years ago, to make this happen because of the limited size of the property. This whole application or the whole variance involves 98 square feet of deck that's within the setback area. The deck will not be visible from the lake. The cabin is now not visible from the lake because it's only one story, and there's an 18-foot rise from the high water line to the grade at the front of the cabin. So you're looking uphill. I received today, just an hour before I came, some letters that Jason sent. We were traveling this afternoon up here, so I didn't get a chance to read them thoroughly. Tried to read them on my phone. I don't have my computer, but the DNR brought up some issues. They stated the grade difference is approximately 2 feet from the cabin, I believe, to the top of the property. That's not true. It's 4 feet. It's actually 5 feet to an outbuilding, and it'll be about 3.5 feet to the where the drain field starts. So I'm not sure where they got that information, but when it comes to this property, we haven't removed any trees since the early 1960s. The lakeside is a steep slope. The trees are what hold the slope. The only thing we've done is when we purchased it from my great uncle Glenn, there were stones that were just set in the dirt on the way down to the lake, and they eroded. And so we put in a steps that was made from railroad ties to stop that erosion, and have had no erosion since. And we intend to maintain that in the future. We've been ecologically responsible, involving the care of the property. Most of the green area around the cabin is still original. It's new trees that are coming up. It's my mother plants wildflowers along the fences where they won't be disturbed, that are native to Wisconsin. And we don't use fertilizers. We intend to keep it that way. We want a minimal yard to mow, only what needs to be done, like for the drain field and so forth. So as far as being ecologically conscious, I don't think you can find a better tenant for the property. We've only had a powerboat on the lake 5 days in the last 7 years. Our primary use of the lake involves canoes, kayaks, and paddleboards. And so at any rate, this is a handicapped accessible home. It makes sense to provide a deck where you can sit in front of the home. There are many other reasons that I'm sure you've all read, and apparently you visited the property. So I won't go over those. Both my parents were in a wheelchair for a period of time before they passed, and my father for several years. And I would wheel him around the cabin over rough ground, and which was painful for him. But my father came to the cabin when he was 10 years old back in 1930. So anyway, we have a lot of history here, and this is all about 98 square feet of deck. As far as it being causing any erosion, we have a deck at home as well. We have 2 to 3 inch rock under the deck, and a pervious layer. So I think if anything, it'll stop erosion, because the water will go, any water that goes through the deck will hit the rocks and not erode the soil. So I guess beyond that, I could make some comments about the planning and zoning department. We've had some misunderstandings, but I will say that they have treated me respectfully and with a smile usually, and been helpful. Jason's been helpful in explaining the Wisconsin statute 59.692, which I interpreted quite different than he did. And so I think at this point we have a good relationship with the county, but this is what we'd like to do. We don't see how we can move the cabin without causing major problems grade-wise. And it'd be a lot easier to explain that at the property than would right here. But with that, I'll close my comments.
Okay. What, the elevation, we don't have any elevation drawings. How high is the basement out of the ground?
You do it of the proposed structure?
Proposed structure. Got some floor plans, that's all I've got. So I'm trying to determine what's the height of the deck off the grade.
Well, it's gonna be near grade, right? Because you're gonna have a.
The deck will probably, in the front of the cabin right now, there's 4 steps down to grade, and the deck will probably be 4 steps up, which is probably what, I would say it'd be about 4 feet above grade there, unless we change the grade, which we don't intend to do.
Just trying to make sure I understood it.
Mm-hmm. property falls off towards the lake, so the road end of the new lake home will probably be, you know, a step up into from the grade.
Near grade, yeah, with the driveway, because that's coming into the garage.
Driveway will probably be about 12 inches below the cabin or the lake home, first floor.
So we got a basement, first floor, and second floor.
Yes. Basement will be strictly
Second floor
for,
go over the garage.
does not.
Does not. Now, how high are the walls on the garage?
The garage, it'll have an 8-foot garage door and walls high enough to support that, so.
Well, and let me just make clear, I guess we all understand, this is really just the deck. Yep, so the house, you could build the house right now.
Because the house meets the setback.
With the average
Right, so
setback.
it's just a deck. I get that. I'm
Yep,
just trying to
okay,
get-
just wanna make sure, yep.
The deck will not be visible from the lake.
So we need to meet the 3 criteria.
Okay?
And we can't make the 3 criteria with the deck where you're proposing. Would it, because there's alternative solutions. So the deck in front of the garage. Oh, side.
There's a fireplace right there.
Put a door there and go out on the deck there.
That's,
You have a larger deck.
the fireplace can't be moved
No.
because we're gonna have solar panels and it was strategically placed there. You wouldn't be burning a fire if you have a south wind.
By the looks of this, you don't need to remove the fireplace, you just put a door next, there's plenty of room there.
I disagree with you.
We don't actually have dimensions to know that number of feet would be from the side of the.
If there's room outside to put that deck there.
Behind the garage,
Alongside, yeah,
well,
then you meet the setbacks. So there is a place the deck could go. Might not like it there, but that works.
okay,
There's a place to put it.
well,
And there's nothing in the thing that says a deck is required, or mandatory, or needed.
that's correct.
Or unnecessary hardship, or anything like that, so we can't meet that criteria somehow.
Okay,
That's what we're just trying to give you some ideas.
we'd have to eliminate the fireplace if we put the deck where you're proposing.
That could be. It says you gotta have a fireplace.
I would
The fireplace go on the other end.
It can't go on the other end because now it's on the north side of the property and it's solar panels. We intend to heat the property with a geothermal if possible, if we can squeeze a geothermal well between the garage and the property line there, but, so we can't flip the interior is what I'm saying. For that reason.
What, type of fireplace were you planning to use?
We were hoping to get use a wood fireplace at EPA. We have one at home now and it's, an EPA fireplace. Once it's started, you don't see any smoke coming from it whatsoever. So, and they have, the recent, improvements on fireplaces, make them more efficient than even the older ones, so.
Questions?
There's a door currently, where you show the deck that you wanted, correct? There's a.
That's correct. That's
Is
correct.
that door going to remain there? Or
It'll remain there whether there's a deck or not, yeah. It would remain there, yes.
Okay, was there somebody online input on this one?
Yes.
Should we start there?
There's one.
Okay.
Thomas.
Hello?
Hello, Thomas. Can you hear us?
This is Thomas Hendrickson. Are you addressing me?
Yes,
Yeah.
yep, you can begin.
Yes, I'd like to state that my family and I have no objection to the variance. We're neighbors to the Francises, Tom Francis and his family, since in the 1960s, to the south side of his home or his cabin. We have a copy of the plan. The layout of the lot and the new construction are very familiar with where this deck will be built, and have no objections to the variance that he has requested for the building of the deck. I'd also like to state that I've known Tom since, as I mentioned, in the 60s when his parents owned the cabin. And I am very aware of his efforts and knowledge of how to mitigate any conservation or ecological issues that could have a negative impact on the lake or the bank, the shoreline. And so I'm very confident that he would do anything to preserve the area. And so once again, I want to comment that we are in agreement or have no objections to the variance he has requested. Thank you for your time.
Yes. No, that's it. Okay, and then, anything from municipality or letter, we got the DNR letter?
That's the DNR letter.
Did you get a chance to read the DNR letter?
Best I could. I didn't have much time to study it, and it's, on my phone, it was pretty small, so. They obviously haven't been to the property.
Yeah, I think
No,
we'll
they-
read it into the record
yeah.
since you haven't had a chance to get that.
They don't go to the property.
Yeah, I mean, if they did, and if they could see the stakes in the ground, see where things are gonna go, they would see how it would affect grade differences. Especially back in the house, if you were to back the house up from the lake farther, it would push the drain field can't change.
Yeah.
Because there's modeled soil, at a depth that's, where they can't lower that, let's put it that way. It has to stay where it is. And so, we'd have to build a retaining wall around it, may have to do some of that as well, but now I have another erosion problem. So hopefully you can do that with vegetation.
Yeah, we'll read that into the.
Okay, we'll just read this for you. The Department of Natural Resources has received the notice for December 6, 2021, public hearing concerning the variance requested by, request submitted by Tom Francis. The variance request is to build a new deck that will be 49 feet from the ordinary high water mark of Sand Lake. A new house will be built at the average setback of 57 feet without a variance needed, and the new deck is proposed lakeward of the new house. As the board reviews these variance requests, please keep in mind that the applicant has the burden of proving that their application meets all of the statutory requirements for the granting of a variance for each variance request. That is, the applicant must prove that they will suffer unnecessary hardship if the provisions in the county's shoreland zoning ordinance are literally enforced. The Wisconsin Supreme Court has made it clear that proof of unnecessary hardship by itself does not entitle an applicant to a variance. In addition, the board should consider whether the proposed project is for the minimal relief necessary. All of the statutory variance criteria must be satisfied in order to grant a variance. They are unique physical limitations. The applicant must demonstrate that unique physical limitations, wetlands, steep slopes, streams, rock outcroppings, or special conditions of the property exist that prevent compliance with ordinance regulations. The physical limitations must be unique to the property in question and not generally shared by other properties in the area. When determining if compliance is prevented, the whole parcel must be considered. The applicant is choosing to construct the new principal structure at the average setback. The new structure could be redesigned or moved back toward the road. The grade to the road of this property is only 2 feet higher than where the current roadside proposed wall is planned. The slopes on this lot do not appear to be unique to this property. No harm to public interests. The applicant must demonstrate that variance will not result in harm or be contrary to public interests. The board must consider the impacts of the proposed project as well as the cumulative impacts of similar projects on the interests of the neighbors, the community, and the general public. These interests are listed in the purpose statement of the ordinance, and for that shoreland zoning include protection of public health, safety, and welfare, maintenance of clean water, and protection of fish and wildlife habitat, and preservation of natural scenic beauty. There is a significant amount of science that a 75-foot setback is really needed to maintain a healthy lake. The cumulative impacts of placing structures so close to the lake can multiply the detrimental impact on fisheries, water quality, natural scenic beauty, etc. Unnecessary hardship. An applicant must demonstrate that if the variance is not granted, an unnecessary hardship exists. The applicant may not claim unnecessary hardship because of conditions which are self-imposed or created by a prior owner. For example, building a home in compliance and then subsequently constructing a deck without a permit. Courts have also determined that economic or financial hardship does not justify a variance. When determining whether unnecessary hardship exists, the board must consider the property as a whole rather than just a portion of the parcel. A deck is not needed to make reasonable use of this property, and there are several design options that would allow the same size cottage and a deck on this site. It may be possible that the applicant will provide additional evidence at the hearing which may change the conclusions above. It is the responsibility of the Board of Adjustment to assure the statutory standards for granting a variance are met. The standards help to ensure protection of the public interest, including the preservation of water quality and fish and wildlife habitat along lakes and rivers. The Wisconsin navigable waterways are held in trust for all people to enjoy. The shoreland setback is important to protect the water quality, natural scenic beauty, and the fish and wildlife habitat of Wisconsin waterways. The department appreciates your commitment to Burnett County's water resources and protection of public interests for future generations. Sincerely, Kathy Kramitz, Water Management Specialist.
Thank you. And then, did you receive the Burnett County staff report?
I think Jason sent that today as well, and,
Have a chance to read that. So one of the things on there is any violations of record, and it says no sanitary permit exists. Where is the existing sanitary system on the?
it's, the flags are in the ground. That's troubling to me because that was brought, and I paid Tompkins Sand and Gravel $900 to submit the permit, and they cashed the check. And I wasn't aware that they hadn't, applied for the permit.
For the new system though.
For the new system.
Yeah, I'm saying, right now,
existing.
there's a privy.
That's why we want to do this.
There's an existing privy?
You don't have a septic system, in other words, just
We
your.
do not have, the gray water that comes from the kitchen sink goes into a 55-gallon drum of rocks that my father put in the ground, beside the cabin in 1960. Never been a problem, never, but just the gray water.
Of course, it needs to be corrected. Where is that barrel? Is that going to affect your new well or anything?
The barrel will be removed. It's right under the garage. The garage will be right over it. That's what I was told. I didn't see him do that. That's what I was told he did. So. Soil is, it's all sand there.
Okay, so that's all, that's nothing else for anybody else? That's everything.
Really be nice if the DNR person would come out there and see exactly what we're doing and why we don't want to move it in any directions, but at any rate.
They're just doing the facts of the law, that's what they're addressing, really.
Yeah, yep.
And that's what we have to go by, we don't have it, we can't not follow
I
the law.
think they knew more about this, the property, we minimized the dimensions of the lake home to start out with. In fact, since talking with the land use department, we lopped off 8 feet of depth to the cabin, just to make it fit. And we've also held the same dimension from the lake, or the 30 feet east-west, which is the same as what the current cabin is, just to make it fit. So we've tried.
Any questions, Kathy, that you have? So we'll close this portion of the hearing, we'll deliberate amongst ourselves, and you'll do the determination. So the 3 criteria are the issue we've got with this one. Unnecessary hardship, we can't meet that, we can't meet the property limitations. There's alternatives, so you can make this deck just by putting it in front of that garage, move it, even if you had to move it, it looks like you got way more than 3 feet here. But even if you had to move that fireplace over into the garage just a little bit more, you center it on the wall even. Why even put the doorway and go out there? You have handicap accessible. And then you're back, then you could have twice the size deck, you could have 24 feet instead of 12. So there is alternatives. And if you had retaining walls or something, move the whole bay, you can do that too, but there is physically room on it. We don't have the physical limitations that we're running into in some of this.
So if they, didn't have the deck in front and they still wanted to have an exit there and still needed some sort of steps, would they be within the setback then or not? If they still came out in front?
Jason would have to answer.
Well, it sounds like, I think you're 1 foot behind the setback, I think, with the house wall. We typically allow people some stairs to get out of their building just for safety purposes, but, you know, you can't have the deck, but we would allow a set of stairs to get in or out.
Would it be allowable to have that small set of stairs and then have a walkway, the width of the stairs to go to put the deck in front of the garage? Or is that, so then it becomes violations?
Yep.
So I think this one, we just can't meet the 3 steps. We have to meet all 3, and we can't do that. So I think we don't have a choice but to deny the variances requested.
A motion.
That's a motion.
I second the motion just because of the 3 criteria that we can't do.
So the motion and a second, all in favor, signify by saying aye.
Aye.
Carried.
That's also there, you know. So you don't have any to sign from last month, so I think you can basically adjourn.
I make a motion that the meeting be adjourned.